Hello, my name is Helena Kennedy, Baroness Helena Kennedy, and I'm the director of the International Bar Association's Human Rights Institute. And let me start by welcoming everyone to this webinar. And as you know, it's entitled Tools for Justice and Accountability. And we're looking at universal criminal jurisdiction over enforced disappearances. And I want to immediately say that the co-organizer of this event, this webinar, is the UN Working Group on Enforced or Involuntary Disappearances. And the webinar has a whole number of co-sponsors, and I want to thank them. The IBA's Criminal Law Committee, the IBA's Human Rights Law Committee, and the International Association of Judges, all of whom we thank for their partnership and support in today's exchange. Now, for those who may be unfamiliar with the UN Working Group, it is one of the thematic special procedures of the UN Human Rights Council. It was established in 1980, and it's composed of 5 independent experts. It has the primary task to assist families in determining the fate and whereabouts of their loved ones who have disappeared, and it's expected that they've been forcibly and reported as such. The working group also monitors and assists states in the implementation of the 1992 Declaration on the Protection of All People from Enforced Disappearances. And in this context, it issues thematic studies, one of which we will be discussing today. Now, today's webinar is a follow-up of an event which took place in January of this year in Geneva, which was the First World Congress on Enforced Disappearances. It convened over 600 in-person participants and 1,200 online attendees from 118 countries. So it was a really serious process. The Congress provided a platform for sharing experiences, coordinating different efforts, developing recommendations, and making pledges towards collective action to eradicate enforced disappearances. Now, as you all know, enforced disappearances of people is a serious violation of multiple human rights across the spectrum, and a crime under international law that inflicts profound suffering, not just on its victims, but on their relatives and on society as a whole. As recalled by the UN Working Group on Enforced and Involuntary Disappearances, the jus cogens nature of the prohibition of enforced disappearance gives rise to obligations for all states to adopt all necessary measures to ensure that such violations do not remain unpunished. And the working group has noted that a growing number of states have adopted domestic legislation incorporating universal jurisdiction to prosecute international crimes. However, universal jurisdiction prosecutions and trials still rarely proceed in cases of enforced disappearances, and that's for a range of reasons that we will be discussing. The working group's recent research study, which was presented to the 60th session of the UN Human Rights Council earlier this month, assesses the use of universal criminal jurisdiction in cases of enforced disappearances, and it analyses the applicable conceptual and legal frameworks, the existing challenges, the lessons that have been learned, and the good practice in investigating and prosecuting enforced disappearances in different instances. This webinar offers an opportunity to share the findings of the research study. And it really is important for the legal profession to take it on board, to examine legal frameworks and issues, and reflect on our own practitioner perspectives. Judges, prosecutors, and lawyers play a crucial role in covering justice and accountability for this crime. By better understanding the legal and procedural challenges and the opportunities that are afforded by universal jurisdiction to investigate and prosecute such crimes is something that we as legal professionals really have to take on board. We can better protect and promote human rights and prevent impunity for this crime if we really know in some detail how it operates, how it can be dealt with, what the research is, and so forth. Now, we've got a fantastic panel of speakers, and I'm going to call on them one by one. As you've heard, the starting point, I think, and it's a good one, is to look at the findings of the UN study by the body, the working group on this particular issue. And I'm going to invite our speakers to come in on that. Our first is Gabriela Citroni, and she will be speaking to you with Grazina Baranowska, who is the chairperson and the vice chairperson of UNWGEID, as these initials that permeate our lives have to be remembered as to what they stand for. But they're going to look at the existing challenges and the lessons learned. So can I call upon Gabriela? She's, as I've just said, she is the chairperson of the UN Working Group on enforced disappearances. And she has had she has a whole set of academic positions, but she is also the international legal advisor for the Latin American Federation of Associations of the Relatives of the Disappeared. So I'm going to call on you, Gabriela, first, and then Grazina, who's the vice chair, and she again is a very distinguished academic, a professor of migration law and human rights at the Friedrich Alexander University in Germany. So Grazina and Gabriela are the co-rapporteurs of the working group study. Gabriela, over to you first.
Thank you very much, and thank you for co-hosting and co-sponsoring this event, which, as I was saying, is of particular relevance for the working group on enforced or involuntary disappearances, because it is true that we presented over the past 2 weeks at the Human Rights Council the report, but this is the first time that we have the chance to look into it a bit more in depth, and in particular with professionals. So I thought that it would be good to maybe take a step backwards and tell you why did we decide, out of all the potential subjects that we could have covered in thematic studies, to look into this. And I'm not going too much back, but at least 2 years ago, in September 2020, you will find a press release that was co-signed by this working group, the Committee on Enforced Disappearance, and other UN experts, which was welcoming, and I'm quoting, the landmark trial that was starting over those days in Switzerland on a case of enforced disappearance on universal jurisdiction basis concerning Belarusian defendant. So why were we welcoming, or why did we consider it so important out of all trials to make a press release just to celebrate the fact that it was taking place? Because we realized that it was the first, at least to our knowledge, pure universal jurisdiction case of enforced disappearance that was about to take place. Fast forward, the case, so the defendant actually confessing, but eventually he was acquitted because of the interpretation given by the authorities to the crime of enforced disappearance. So I still consider the fact that the trial took place something that triggered our attention to why, out of all cases of enforced disappearance universal jurisdiction that are taking place these days, there are so little that concern enforced disappearance. And that is the whole rationale behind the study. If we take into account the fact that there are a growing number of enforced disappearances, it is a crime where the rate of impunity is one of the highest in the world, considering its complexity for multiple reasons. And the growing use of universal jurisdiction, to us, it didn't really sum up why there were still so little cases. And that's when we decided to start looking a bit more in depth into this. To do so, we also an academic visit precisely to Switzerland, where authorities were kind enough to meet with us, both in St. Gallen, that is where the trial that I was mentioning took place, and in Bern. And then we started collecting documents and issued also a call for inputs that was I would say a particularly successful one, where we received contributions from all over the world. So the study aims at capturing the findings. And I have to say from the outset that In the title, we use universal jurisdiction, but to be a bit more accurate, we look into extraterritorial jurisdiction, precisely because universal jurisdiction in the pure sense of the word, we most likely wouldn't have had cases to analyze. So we opened up a bit to states that apply principles of passive or active personality. And some of the obstacles that we identified for the use of universal jurisdiction in cases of enforced disappearance as a tool that effectively prevents impunity vis-a-vis this heinous crime are common to other crimes, I would say. But some are very peculiar and are related to the features of this specific crime. What we realized is that there have been a number of cases that actually are cases that could have been qualified as enforced disappearance, but were prosecuted as ancillary crimes, which better than nothing, some would say, but nevertheless, most likely misses the complexities of the crime. Disappearance is a particularly complex crime because of the plurality of perpetrators, plurality of victims, and plurality of conducts. So none of the other ancillary crimes covers and encompasses everything. We identified let's say, 4 sets of states. States that do not codify enforced disappearance as a crime, period, and do not have provisions in their domestic legislation that allow the application of extra-territorial jurisdiction and universal jurisdiction in particular. Others do codify enforced disappearance, do not codify, enforced disappearance, but do allow for the application of universal jurisdiction. The third category are states that do codify enforced disappearance and allow for the application of universal jurisdiction, but as of today, they have never, for whatever reason, applied these provisions in cases of enforced disappearance. And finally, those that codify enforced disappearance and universal jurisdiction, or have all the provisions in the legal framework and have started to use this. We focused our study on 4 main case studies, being France, Germany, Switzerland, and Argentina. The reason is because these states fall in the 2 last categories I mentioned. So they, let's say, have the equipment and they are geared up for the use of enforced disappearance of universal jurisdiction in cases of enforced disappearance. And they have done so, or sometimes, encounter some obstacles. So I would I would give the floor to my colleague Grażyna, but I would mention that the very first obstacle we encounter for the use of jurisdiction in cases of enforced disappearance is the criminalization of enforced disappearance. If a state does not codify the standalone crime of enforced disappearance, that's problematic because it will be bound to use ancillary. And we also noticed that when it is codified properly, it should be codified both as a standalone crime and as a crime against humanity. And those are in line with international standards. When that's not the case, this triggers problems also in the application of universal jurisdiction. Another layer is how those provisions are interpreted. And in some cases, we've noticed that this is interpreted too narrowly, or at least adding conditions are not there in the international legal framework, which eventually prevented the use of universal jurisdiction. With this, I would hand over to Grażyna.
Thank you, Gabriela, and thank you also for having us here and for discussing with us universal jurisdiction and enforced disappearances. So among the legal obstacles, one of the issues that we also highlighted are immunities as an obstacle. And after shortly talking about immunities, I will move on to 3 more practical issues that might be also very relevant for prosecutors and for practitioners more than for those that make the law, as the definitional issues is an issue. And I will close up with one big finding from our report, which concerns participation of victims, representatives, and civil society. So starting with immunities, we found that it is still, in many instances, but the principle of immunity, both personal and functional, an obstacle to commencing proceedings under universal jurisdiction. And we did find a couple of good practices that we do highlight in the report, but overall, it remains an obstacle that should be addressed, and that is a highly an obstacle to achieving that. Now moving to the three practical issues. So first of all, we found that specialized units that have a know-how on enforced disappearances are much better placed and much more effective for achieving success. And this holds true in every proceedings concerning enforced disappearances. There's know-how about the particular crime, but even more so in universal jurisdiction, where the challenges are more complex, also covering necessary know-how about the context, about the country where that has happened. So having a prosecutor and legal professionals in the team who understand how enforced disappearances are operating is really something that's extremely helpful in having effective proceedings. Some of the good practices that we highlighted in our report concern specialized Department of Crime under international law in Germany, or crimes against humanity and war crime units in France, as well as a number of other countries that have similar approaches. Since our interest, as Gabriela pointed out, also stemmed from a particular problem that we have seen, we also asked a question about federal states and what are some challenges that federal states are faced with when addressing universal jurisdiction. And one of the findings that we have included in our report is that it is federal authorities that are usually better placed and equipped to exercise universal jurisdiction in such complicated cases as enforced disappearances, whether they are a standalone crime or a crime against humanity. So this would be a particular finding with regard to federal states. Moving now to securing evidence and applicable criteria, that's actually very much connected to the earlier case, because we found that it is specialized units that have the best potential and also the best know-how to secure evidence and to understand it and to best map it. And for that, one of the very good practices that we have found is the so-called Strukturenverfahren, that is the structural investigation conducted in Germany, which allows to map and find very different issues that are then helpful when addressing enforced disappearances, even in singular cases. We have noted that such structural investigations are conducted particularly with regard to Syria, and that concerns not only Germany but also other countries such as France, but also with regard to Ukraine. There is this collection of know-how within structural investigation that helps addressing that. In this context, one initiative that is particularly worth highlighting is the International Impartial and Independent Mechanism to assist investigation and prosecution of persons responsible for the most serious crimes under international law committed by the Syrian Arab Republic since 2011. And this particular mechanism allows to share knowledge and support also domestic investigations. Of course, we need to recognize that there's a limit of creating such independent institutions with regard to various conflicts around the world. However, it is noteworthy that there are very exact and detailed successes that can be attributed to this particular mechanism, and as such, it's noteworthy to be repeated also in other contexts. And lastly, mutual and legal cooperation and assistance. And here we have pointed out particularly cooperation within the European Union, which is particularly useful, and there are good practices of that. And I assume we also have here experts that have earlier cooperated with the EU genocide network or within joint investigation that have been developed within Eurojust. So those are such examples that allow to better address enforced disappearances. So now coming to the last point, and here that is the families, representatives, and civil society. And we have found that there's still really huge obstacles in engaging them in proceedings. And the reasons for that are several. They very often are outside of the country where the proceedings are or are conducted, and there's not an effective way to bring them in, to keep them informed, or to have them in the proceedings themselves. There seems also not to be sufficient psychosocial support to victims during the proceedings, both those in the country and those outside of the country, as well as an obstacle that we have heard and read about a lot is the lack of interpretation and translation that concerns the proceedings. And those makes victims and families not available to access and understand what's happening in the court, which with regard to a crime like that is, of course, particularly problematic as the families themselves have been addressed by the enforced disappearances, and the proceedings are a form of redress that they should be able to participate in and to learn from that. And because this was one of the huge obstacles that we have encountered, also in the recommendations for the report, that is the last 2.5 pages of the report, you would see that there's a considerable part of the recommendations that specifically address victims, families, and civil society organizations. So thank you very much.
Well, let me thank both of you for really presenting us with some very interesting and important information about that you have gleaned and that have been part of this report. One of the challenges that I think exists certainly for us here in Britain, but possibly in other countries, is that universal jurisdiction has been introduced into law in the United Kingdom. However, it will only apply to those who have become citizens. The only people who can be arrested and put on trial are citizens of the United Kingdom or people who have residence in the United Kingdom. And one of the things that we know is that people, for example, come to Britain for medical treatment, people who've been involved in the conduct and perpetrating these kinds of crime. They come to find university places for their children, and the opportunity of making arrests is not available in the United Kingdom because of the restrictions of how this law is being applied. And so I wondered if those challenges are ones, and I'm not asking you to answer just now, but it's something that I think that I would like to hear from somebody about that rather limited way in which some nations interpret their universal responsibilities with regard to grievous crimes. I'm going to then turn us now, thank you both, because that was really, really interesting and important, Gabriela and Grazina. Can I turn to Professor Olivier de Fruville, who's the Vice Chairperson of the UN Committee on Enforced Disappearances. And I'll tell you a little bit about Olivier. He's a professor of international law in Paris. He's a director of the Paris Human Rights Center. And more specifically for the purposes of this discussion, of course, as I've said, he is the Vice Chair of the UN Committee on Enforced Disappearances. He was the President Rapporteur of the UN Working Group on Enforced Disappearances, so really has considerable expertise. Olivier, can I invite you in, please?
Thank you. Thank you very much, Baroness. Thank you very much for the invitation by the working group and also by the International Association of Judges and the International Bar Association. I think this is a very timely initiative. And I will explain more in details why I think it's so important to speak about, let's say, prosecutions, criminal actions against perpetrators of enforced disappearances now, and more particularly in the context of universal jurisdiction. So I've been asked to talk about the legal framework, which is provided for by the convention, focusing on universal jurisdiction. And I would start maybe by saying that for those who are familiar with the Convention Against Torture, which is more well known, the framework of universal jurisdiction is pretty much the same, although there are some additions and some kind of new features that were added by the authors of the convention to improve the mechanism. If you look at Article 9 of the Convention, you will find the different types of jurisdiction that you already find in the Convention Against Torture. So the territorial jurisdiction, of course, but also personal jurisdiction, passive and active, and also what is called the universal jurisdiction, but with the condition of the presence that the person is found on the territory, and certainly not the residence, as you've just said. There's only condition is that the person is found on the territory of the state party. Article 11 provides for the classical principle of aut dedere aut judicare, that is the state that arrests the person on its territory has the choice either to put the person on trial, to investigate the person, or to extradite the person, also to hand over the person to an international tribunal. And that's something that was added in the language of Article 11 as compared to the Convention on Torture. This possibility of making space for the competence of international tribunals that were accepted by the state party. This must, and the starting point for all of this is, of course, having a crime, which is integrated in domestic criminal law. Article 2 provides for the definition of enforced disappearances, but also to mention Article 3 of the Convention, which makes it an obligation for states party to prosecute similar acts, you would say acts tantamount to enforced disappearances, but which have been committed by non-state actors, so persons not acting with the authorization, support, or quiescence of the state party, like armed non-state groups. You will also find in the convention, and this should be integrated in the convention, a number of things that go along with the criminal mechanism, that is the different kinds of responsibility, that is the ordering, soliciting, inducing the commission, attempting, being an accomplice in perpetrating an enforced disappearance, but also the superior order, which comes from international criminal law and also has to be integrated in domestic law. The general case for superior order is demanded, is requested by the convention under Article 6. The specific case for the militaries is not, let's say, mandatory, but is very strongly recommended. And you would also find an exclusion of defense for superior orders, of course, which is also a classical principle. And another thing which is extremely important as far as enforced disappearances, and which is specific to enforced disappearances, I would say, along with other crimes, but for international crime, this is really specific, is that it's a continuous crime. So it means that in particular, when there is a statute of limitation, counting of the statute of limitation should only start when the crime ceases. That is basically when the person is found, whether the person has been found dead and the remains have been identified, or the person has been hopefully found alive. There are also obligations for mutual assistance on the criminal side, Article 14, and also in the search of victims of enforced disappearances, and this is Article 15. And then finally, with the legal framework, I should also mention Article 25 of the Convention, which specifically concerns the abduction of children, enforced disappearances of children, forced removal of children, and subsequently the falsification of documents and illegal adoptions of children. And this is something that was framed from the experience of Latin America, and in particular Argentina, and all the children that were stolen from the parents who were submitted to enforced disappearances, children that were themselves submitted to enforced disappearances. But it could be also applicable, and it is applicable to more broadly to international adoptions, to illegal adoptions, including in its inter-country dimension. So now I would just like to, and so you see the framework I think is fantastic. It's very exhaustive. It covers all the possibilities, and it should facilitate the prosecutions of perpetrators of enforced disappearances. If it were well implemented, I would say, in domestic law, and that's probably the problem, as Lacina and Gabriela have underscored. There are very few cases which have been prosecuted until now, especially on the basis of a universal jurisdiction. And why is that so? Well, I think there are many reasons, but I would just focus here on the legal reasons why there are so few prosecutions of enforced disappearances based on extraterritorial jurisdiction. The first reason is that for many states that do have enforced disappearances in their criminal code or criminal framework, they don't have it because they are a party to CED, to the convention. They do have it because they are a party to the Rome Statute of the International Criminal Court. So they have it as a crime against humanity, but not as an autonomous crime. And I could come back on this, but we could also have a more focused discussion on this. But there are many obstacles to prosecuting enforced disappearances as a crime against humanity because of the definition that is given in the Rome Statute. And especially the Rome Statute has added, if compared to the definition of the Convention, an intentional element, which contains itself a temporal element, which complicates the task of let's say, the prosecuting authorities if they have to, or if they were to apply this particular definition. Now, there are also some states that keep on refusing integrating an autonomous crime of enforced disappearance, even though they're party to the convention. And as a member of the committee, I can tell you that every year we review states and we have discussions with states that try to explain to us that they don't need to integrate an autonomous crime of enforced disappearance because they already have crimes of abduction, arbitrary detention, and this is more than enough. And we have to keep on explaining them that this is not true, and for many reasons. We have had these discussions for 10 years, sorry, with Germany. Germany that came the first time in 2014 and explained that they were well off with their existing crimes, and they came back again in 2024 having the same explanations, and we kept on explaining why it wasn't true. And then finally they changed their law, and they finally integrated a crime of enforced disappearances. Because this was part of and this was a reaction to our recommendations, but this was also a reaction to some other events, including trials that took place against Syrians responsible, and it appeared this time that it was not good that domestic legislation did not include an autonomous crime. Then there are some states that have included enforced disappearances, but they have not done it correctly. And again, this is something we often see in discussions we sadly have with a number of states parties, that they had this process of integration of the convention before the parliament. There was a law that was proposed, discussed, and they come very proudly before the committee and say, yeah, we have a law and we have a crime of enforced disappearances, but we have to tell them sadly that the way they interpreted the crime is not correct, because they dropped an element, they added a new element, because the penalty is not correct, because also in a number of cases they don't include a number of things that are complementary to the definition, like the continuous crime dimension, or the different types of responsibilities, etc. So I think, beyond all the practical reasons that may explain why there are so few cases, there are a number of legal obstacles, which I think if we would work a bit on it together, if we would coordinate, or if we launch a kind of common action, would be easy to overcome. I don't think that these are particularly complex issues, but it needs a bit of coordination and a bit of common action to overcome those issues. So that's why, following the World Congress on Enforced Disappearances that you mentioned, that took place in January 20 2025. There were two panels dedicated on prosecuting crimes against prosecuting enforced disappearances during the World Congress. And after the World Congress, my research center and the Geneva Academy decided to initiate or to organize a panel of experts to start a reflection about how to improve the law and how to also coordinate. And I guess as a conclusion, my call would be to continue this effort. I think this would be very important today to initiate a kind of network of experts on enforced disappearances to see how best to facilitate the fight against impunity, prosecution, and especially on these legal matters, which again, I don't think would need so much effort to overcome. So thank you very much.
Olivier, thank you so much for that. And it's really, really interesting that you're hearing your experience. It does seem to me that the International Convention could be used for the children who've been taken from Ukraine by Russia. Because a whole set of them, we suspect, I chair the task force for their return, and I co-chair it with the chef de cabinet of President Zelensky, and many of the youngest children we fear have been adopted and have proof of adoption in some cases. So it seems to me that it may be that that those cases may be ones that could be looked at by many jurisdictions if people travel within them who are involved in the processes of running the convention, for example, on children of Russia, etc. That there are officials who have do not have clean hands when it comes to this. So thank you very much for that. And I'm now taking us on to the practitioners' perspectives. And we couldn't do better. We've got two really incredibly experienced practitioners. We first of all have the Honourable Mr. Justice Clayton J. Conlon. He is from the Ontario Superior Court of Justice in Canada, and he's a co-president of the International Association of Judges, Third Study Commission on Criminal Law. He has held considerable distinguished roles, and we're really delighted to have the Honourable Mr. Justice Clayton Conlon with us. We also have Shoshana Levy, who's been a prosecutor of great experience. She was the special assistant to the International Crimes Prosecutor. She was in the specialized unit for crimes against humanity and war crimes of the National Counterterrorism Prosecution Office in France. And again, both of them will address this issue of legislation, looking at universal jurisdiction legislation in cases and reflections upon them, and the ways that we might urge nations to basically progress the work that could take place on this front. So can I turn to Mr. Justice Clayton Conlon, please?
Merci beaucoup. Thank you very much. Bonjour à toutes et à tous. Good day, everyone. I am pleased to be here. I'll get right to it because I have limited time. So the first point I'd like to make is that enforced disappearance is not a standalone autonomous crime in Canada. Canada has, however, implemented legislation that establishes jurisdiction for the prosecution of certain international crimes. Canada incorporated the obligations of the Rome Statute into its national laws when it adopted the Crimes Against Humanity and War Crimes Act in June of the year 2000. Canada was then able to ratify the Rome Statute in July of 2000. In a case called HAPE, H-A-P-E, decided in 2007, the Supreme Court of Canada described universal jurisdiction as jurisdiction by a state over acts committed in other countries by foreigners against other foreigners based on the seriousness of the crime. That is how Canada's highest court described the concept of universal jurisdiction in that case that was decided in the year 2007. According to Section 6, subsection 1 of the Crimes Against Humanity and War Crimes Act, genocide, crimes against humanity, and war crimes are criminalized in Canada, but only in certain circumstances. They are criminalized in Canada when they meet the terms, when they meet the requirements of Section 6, subsection 1. So you might be wondering, what are those requirements? Well, first of all, that section says that every person, either before or after the coming into force of the legislation, commits outside Canada genocide or a crime against humanity or a war crime is guilty of an indictable offense in Canada and may be prosecuted for that offense. But a person who is alleged to have committed an offense may be prosecuted only in certain circumstances. And this is similar to the restriction that was described by Lady Baroness earlier in her comments, because the prosecution may only proceed in Canada if at the time the offense is alleged to have committed, the person was a Canadian citizen or was employed by Canada in a civilian or military capacity. There are other requirements. If the person was a citizen of a state that was engaged in an armed conflict against Canada at the time, or if the person was employed in a civilian or military capacity by such a state that was engaged in an armed conflict against Canada at the time, or if the victim of the alleged offense was a Canadian citizen, or if the victim of the alleged offense was a citizen of a state that was allied with Canada in an armed conflict at the time. So you can see that there are restrictions on the ability to prosecute this type of matter in Canada. So I'd like to switch gears for a moment and talk a little bit about other legislation, Canada's Criminal Code. This is the source of codified criminal law in Canada. And our criminal code does incorporate portions of universal jurisdiction. For example, torture is criminalized as a separate, standalone, autonomous crime in Canada. It is at section 269.1 of the Criminal Code. As well, the Criminal Code lists a number of other crimes to which universal jurisdiction applies. And these other specific crimes include piracy, offenses against cultural property, hostage taking, and terrorism offenses. In my last minute and a half, I want to give you two examples of prosecutions based on universal jurisdiction that have occurred in Canada. They do not deal specifically with enforced disappearance, but they do deal with the more umbrella concept of universal jurisdiction. And I can give these citations, the specific case citations, to the organizers to distribute to the attendees if you wish. The first case is a case out of Quebec, which is one of Canada's largest provinces. The name of the case is Munyaneza, Munyaneza. It was decided in 2009 at the trial level, and then was decided by the Quebec Court of Appeal in 2014. And there was an attempt to appeal it further to the Supreme Court of Canada, but the highest court in Canada dismissed the application for leave to appeal. This was the first ever prosecution in Canada under the Crimes Against Humanity and War Crimes Act. The accused, who resided in Canada as a refugee, was prosecuted for his alleged involvement in the Rwandan genocide. At trial, he was found guilty of genocide, a crime against humanity, and a war crime. He was sentenced to life imprisonment without eligibility for parole. On appeal, the Quebec Court of Appeal affirmed the decision at the trial level, upheld the decision at the trial level, and the Quebec Court of Appeal specifically commented that the Crimes Against Humanity and War Crimes Act explicitly permits prosecution of international crimes and confers on Canadian courts universal jurisdiction over genocide, over crimes against humanity, and over war crimes. So this is seen as a rather seminal decision in Canadian jurisprudence because, as I said, it was the first ever prosecution under that statute. The second example is a case called Mungwarere, Mungwarere. It was decided in 2011. In that case, the accused was arrested by the police in Ontario, Canada's most populous province, in November of 2009. He was suspected of being involved again in the Rwandan genocide. He had originally claimed asylum in Canada in 2001 and had been granted refugee status in 2002. He was accused of 4 counts, including 2 counts of genocide, crimes against humanity, and war crimes. In July of 2013, a Superior Court judge, one of my colleagues in Ontario, found the accused not guilty of the charges that he had participated in the 1994 genocide in Rwanda. The judge acquitted the accused on the basis that the Crown had not proven the case beyond a reasonable doubt.
Interesting.
That's my time, and so I will turn it over to my colleague, Miss Levy. Thank you.
Well, before you do, I just want to say we've all had an incredible lesson in how one can, with very limited time, be concise, precise, and incredibly powerful in a presentation. I want to thank you, Justice Conlon, for that lesson, as well as the content of your contribution. Thank you so much. And then Shoshana Levy, you are going to give us the French universal jurisdiction perspective, please.
Thank you very much. Thank you for your introduction, for your invitation. And I'm really glad that I could have the chance to listen to Gabriela, Grazina, and Olivier first, because I know now that France stands as quite compliant with international law, which is positive, at least regarding its legal framework. Because so we have enforced disappearances both as a standalone crime and as a crime against humanity in our criminal code. Both respond to a different legal framework, which I'm going to expose, but both also are under the jurisdiction of the specialized unit for the prosecution of international crimes. So we have prosecution over the 3 Rome Statute crimes and torture and enforced disappearance. Regarding the enforced disappearance as a standalone crime, the definition reproduces broadly the New York Convention definition and not the Rome Statute definition, which means that we have the requirement of the crime being committed by a state actor or with a state consent or acquiescence. which had repercussion. I'm gonna talk about it a bit later. This framework was entered in force in France in 2013. So we have only jurisdiction over enforced disappearances committed after 2013. And we have a statute of limitation of 30 years. We have also, with this standalone crime, the possibility of resorting to the superior or command responsibility specifically for that infraction, so for that crime. And we have indeed jurisdiction over crimes committed on French victims, and when the enforced disappearances have been committed by French perpetrators, but we also have a framework for universal jurisdiction over that precise crime, which requires the suspect to be present on the French territory, only present. Then, regarding enforced disappearance as a crime against humanity, there is no statute of limitation. There is a possibility to apply common responsibility, and there is universal jurisdiction, but with a framework that is a bit more exigent, because instead of the presence of the suspect on French territory, we have to prove its usual residence on the French territory. And there is also a requirement that there is no request for surrender or extradition from any other national or international jurisdiction. This definition of crimes against humanity applies to crime committed from August 2010, which is the date in which we we transposed the Rome Statute into French law. And for crimes committed beforehand, before 2010, there is a different framework, which is quite unique definition of crimes against humanity, which include a definition which is the kidnappings followed by disappearances, with an additional requirement that it has to be inspired by political, philosophical, racial, or religious motives in execution of a concerted plan against a civilian population group. So this is quite ad hoc definition that applies to crime that have been committed before 2010, and we have some cases open on this legal basis. Then, regarding French practice, we have currently around 150 cases in the special unit. Out of this 150, we have 12 cases regarding enforced disappearances, 4 judicial inquiries, and 8 preliminary examination. You know that in France we have these 2 different type of investigation. One is led by prosecutors, the office I'm part of, and one is led by investigative judges that are independent judges investigating those crimes. So we have 8 preliminary investigation under our jurisdiction. And we have many more actually preliminary examination, many more. I mean, we have double because there were referral from asylum authorities, and this is quite common. That asylum seeker, when they ask for asylum, they just talk about their past in state authorities that have been committing enforced disappearances, and these asylum authorities refer the cases to us. And then, out of those 12 cases, 4 relate to the enforced disappearances as an autonomous crime, and the other are as crimes against humanity. So there are much more crimes against humanity than standalone crime. Half of those cases regard crimes committed in Syria, and you may have heard about the structural investigation regarding the Cesar file. It was this photographer of the Syrian intelligence that came out of Syria was 50,000 pictures. And these pictures have been handed over to the French Ministry of Foreign Affairs, which referred the cases to us, and we have opened a structural investigation into enforced disappearances after the receival of these pictures. And the other cases we have relate to Mali, the DRC, Egypt, Russia, Ivory Coast, Sudan, and Burundi. And if I have 2 more minutes, I will just talk about the 2 cases that we had that could lead to trial in the second case, in the first case that led to a trial. We had a case based on the passive personal jurisdiction. So we had dual national French and Syrian victims of enforced disappearances that filed a complaint and which led to a criminal trial in absentia, which was held in France in May 2014, and 3 high-ranking Syrian officers have been convicted to life imprisonment in May 2024 for enforced disappearances as crime against humanity, along with complicity in war crimes. So we have arrest warrant issued for the 3 of them. And then we could have a case last year when the former spokesman of the armed group Jaish al-Islam, which is called Majdi Nema, had to appear before the Paris Criminal Court on the charges of complicity in enforced disappearances, but the appeal court cancelled his indictment on this charge due to the fact that the criterion of being a state agent was not met in the case of this armed group. And this went to the Cour de Cassation, to our Supreme Court, and the Supreme Court confirmed last year that we could not prosecute member of armed group for enforced disappearances. So he was tried for war crime and was still convicted to 10 years imprisonment for recruitment of child soldier and participation in a conspiracy to commit war crime, but not for enforced disappearances. And that's it on my side.
Shoshana, thank you so much. And you've obviously had incredible experience, and I really do want to express our appreciation of you giving us your time and experience for this discussion. Now I'm going to hand over for the remainder of the session. I'm going to pass the floor to Shirley Pouget, who is a chair of the IBA Human Rights Law Committee, and she's going to moderate the questions and answers. And I know that many of you will want to ask such an incredible panel for elucidation of some of the points they've made or things that may have occurred to you as they were speaking. So I'm going to hand over to Shirley, and I'm actually going to take my own leave of you. I'm having to give a presentation in Oxford this afternoon, and I have to get there from London, so forgive me. But it's been I've learned enormously from hearing from everyone, and I want to thank you all. Over to you, Shirley.
Thank you, Helena. Safe travels. Good morning, good afternoon, good evening, everyone. Thank you for joining. Thank you to all panelists for those presentations and contributions. We do have a few minutes left. I would encourage everyone to use the Q&A chat if you have any questions. We have 3 questions already, which I'm going to pose to the speakers. And I think the first one will go to you, Olivier, which is very much about use cogence. So the first question is, are any UDHR principles that apply universally of state jurisdictions of party to it? Which I think relates very much to enforced disappearance as a use cogence norm.
Well, thank you very much for the question. But I think maybe also Gabriela or Gratina would like to respond because they addressed this issue in the report. Certainly, the UDHR wouldn't be a sufficient legal basis to prosecute someone. That the domestic judges would, in general, ask for a solid and precise legal basis to prosecute someone and also to convict someone on the basis of a crime. But that doesn't mean that international customary law, at least, that is not necessarily UDHR, but the principles that are recognized or the norms that are recognized under either the UDHR or any other instruments might not be used to some extent, at least to fill some gaps in national jurisdiction. Yes, so I'd say it's not sufficient, but it might be useful to some extent to have recourse to international customary law or to general principles of international law, that is unwritten law under international law.
Thank you, Olivier. And the second question could be for you, Gabriela and Grazina. and relates to the Convention on Enforced Disappearances. So do you think Article 9.2 might be one of the reasons for low ratification of the Convention? Briefly.
Well, I will I will try to answer, but I don't think so. I mean, the low ratification of the convention is due to multiple reasons, and hopefully is something that needs to change. But I don't think that that particular provision is one of the issues. And if I may, I would use this opportunity to also answer the question that was left unanswered, because it was asked at the very beginning by the Baroness. And in a way, it speaks to this. States that do apply universal jurisdiction obviously can tailor the conditions under their own jurisdiction. And we've heard from what she described that it's an extremely restrictive condition to apply universal jurisdiction, the fact that you have residence, citizenship. We've heard the Honorable Justice also reading some pretty restrictive conditions. Other states go with the absolute concept of universal jurisdiction, so no condition whatsoever. Others would require the likelihood that a person could be in the territory. I think this circles back to the fact that if the prohibition of enforced disappearance is a jus cogens prohibition, then states should actually draft and craft their legislation in a way that is more conducive to the application of this principle. Because there is no point in drafting a legislation on universal jurisdiction and then entering such restrictive conditions that actually round counter to the very meaning and exercise to such universal jurisdiction. And the article of the convention mentioned, if interpreted properly, means exactly this.
Thank you, Gabriela. We have a couple of more questions and we are close to time. So that question I think is very good for you, Shoshana. It's at the heart of universal jurisdictions and what that means. So any practical ways to bring legal proceedings and obtain binding results when high-level political authorities are involved in enforced disappearances?
Thank you for your question. I believe it's not specific to enforced disappearances. It's a challenge that is general to application of universal jurisdiction. But for enforced disappearances, as we saw, there is a requirement of it being committed by a state actor. So it's inevitably caused the problem of state corporation. In most of our cases, we cannot go to the country of commission of the crime. So we have to rely to alternative manner of investigating, which is mainly testimonial. There are a lot of witnesses and victims that fled from their countries and asked for asylum in other countries. And this is how we can investigate those cases. This is how we get information about what happened there, because we cannot go there. And in this regard, I would support what has been told by my colleagues regarding the importance of cooperation. For example, in Europe, most of the time, suspects, victims, and witnesses are scattered all over Europe. And when we cooperate with the countries where they're residing, we can go interview them. We can also avoid exhaustion of victims, because sometimes many authorities have to interview the same victim, so we can go do it together to avoid this. And yeah, in this regard, for example, joint investigative team are really a good resource for us to bring those cases.
Thank you, Shoshana. And the last question for everybody, and I think Gabriela and Grazina, you can maybe say a few words very briefly about the various jurisdictions you've been looking into, including the cases. So the question is, why are crimes against humanity generally brought against African leaders?
So this is actually not the case in cases that concern enforced disappearances. So all of those cases that we looked into, the majority of the people, the prosecuted persons were Syrians. And there are also others from other jurisdictions. So I do think there is, of course, merit to that discussion, but not in this particular context that we would be looking at.
Thank you, Grazina. So thank you very much to our panelists. Thank you to all our participants for joining. So a few key takeaways. So very few universal jurisdiction trials in cases of enforced disappearances. Many obstacles remain. However, few recommendations to think about: the need to codify enforced disappearance as a standalone offense first, and then as a crime against humanity. The second takeaway, need for legislation permitting collection of contextual evidence. That means the use of structural investigations. The third key takeaway, we need specialized prosecutorial units and the trainings of prosecutors as well as the members of the judiciary in the collection of evidence, but also in running those units. And finally, need to remove obstacles for safe and effective participations of victims. Thank you very much, everyone. Please read the report of the working group in full, take the recommendations at home, and I wish you a good rest of the day.
Thank you.
Thank
Thank you very much.
Thank you. Bye-bye.
Thank you.
Thank you very much.